meeting. The committee for this hearing comprises Councillor Wade. We are joined by Paul Phelan from the Council's licensing team, our legal officer, Michael Feeney. Also with us are our committee officers, Tommy Hammer and Danny Healy. Before we start the hearing for this case, just a few ground rules. Please keep your microphones on mute until you are invited to speak, as only 2 microphones can be used at any one time. And please make sure mobile phones are on silence. Thank you. The case before us today is an application for a new premises licence for Munchies, ground floor, 24 Pembridge Road, London, West 11 3HL. Declarations of interest. I confirm I have no declaration of interest to make regarding this item. Do the other members have any declarations to make? Councillor Wade.
No, Chair.
Thank you.
Whilst I am a councillor, this is in my personal capacity, and it's in that capacity I'm appearing in front of you.
Okay, thank you. Councillor Gardner. I will now go through the procedure, which has already been circulated with the papers. First, the licensing officer, Mr. Phelan, will give a brief outline of the application. Mr. Phelan, can you confirm your attendance, please?
Good morning, Chair. I'm here.
I will then ask the applicant's representative, Ms. Sarah Clover, to present her submission. She will have up to a maximum of 10 minutes to do so. She is joined by Monir Lima, who may be able to assist members should they have any questions. Can you confirm your attendance?
Thank you very much indeed. Good morning. Firstly, may I apologise for keeping everybody waiting. I have had some serious traffic difficulties this morning with a train that broke down and the Circle line is suspended. I have apologised to everybody. May I please apologise to the committee. I'm Sarah Clover. This is not Monir Ahmed. This is Mr. Ajmal Kapalwag, and he is the director of the premises in question, and so he's here to answer any questions that you may have. I hope to be able to do my submissions in 10 minutes. If that becomes difficult, may I have an extension?
I've been asked by my committee member that when you speak, could you speak directly into the mic so we can hear you? Thank you. Then questions may be asked by members of the committee, the legal officer and the objectors of the applicant. Next, the objectors, Councillor Joanna Gardner, Richard Everett and Jane Johnson, will present their objections. They will have up to a maximum of 10 minutes each to do so. Can you all confirm your attendance?
Thank you, all present. We may not all speak, however, which you may not.
Okay. Then questions may be asked by members of the committee, the legal officer and the applicant of the objectors. After this, we will ask our legal officer, Mr. Feeney, to deal with any questions he may have, and then he will lead on the draft conditions session. The list of potential conditions has been circulated to all of the parties prior to the hearing. Mr. Feeney, can you confirm your attendance?
Morning, Chair.
Then finally, we will turn to the governance team to see if any issues have been raised that we need to consider. There will be no summing up and the meeting will end. I would like to remind everyone that the committee has read the papers that have been circulated to the parties, so there is no need to repeat their content, but please do draw our attention to certain points and pages. Let's get going. Mr. Phelan, please can you outline the case for us and advise if there have been any additional documentation received? Thank you.
Chair, members of the subcommittee, good morning all. The matter before you today is an application by Mr. Munchies Limited for the grant of a new premises licence in respect of Munchies, ground floor, 24 Pembridge Road, London, W11 3HL. The application seeks authorisation for the provision of late night refreshment indoors, with the hours applied for as follows. Sunday to Thursday from 11 p.m. till 2 a.m. and Friday and Saturdays from 11 p.m. until 3 a.m. The applicant also proposes opening hours from 8 a.m. each day until close, in line with the end of the late night refreshment period. No authorisation for the sale of alcohol is sought under this application. The premises operates as a restaurant and takeaway, serving burgers, fries and similar food items, Chair. A copy of the application is provided at Appendix B and plans of the premises appear at Appendix C. This application has attracted 5 representations opposing the grant. A summary of these representations appear on page 8 of the report, with full copies attached at Appendix D. Objections primarily relate to the proposed late hours, the mixed sit-down and takeaway model, the potential for noise and disturbance from customers and delivery drivers, and concerns about litter and antisocial behaviour during the early hours. The Noise and Nuisance team initially made a representation, but this was withdrawn following agreement of 9 conditions with the applicant on the 23rd of September 2025. These include controls on deliveries, refuse handling, plant noise, litter, courier management, and the provision of a dedicated contact number. The agreed wording is set out in Appendix B. At the time of writing this report, no noise complaints had been received for the premises in the preceding 24 months, and no temporary event notices had been submitted in the past year. The planning team has raised no objection to this application. Extracts from the Secretary of State's guidance and the Council's statement of licensing policy are contained at Appendices F and G for reference. Chair, members, you will now hear from the applicant and those who have made representations. I'm happy to provide any further clarification as required. Thank you, Chair.
Thank you, Mr. Phelan. Now for the applicant's case. Ms. Clover, can you advise if there have been any amendments to your application?
Chair, there's no amendments to the application. Thank you.
Please can you now present your submission? You have up to 10 minutes to do so.
Chair, I'll try very hard to bring this in within 10 minutes. I would ask for a little more time if required. I know that the objectors have 10 minutes each, but let me get on and see how we do. Can I first of all commend this application to you? As I've indicated, I have Mr. Kapalwak with me here today on behalf of the premises, and he's very willing to answer any questions that you may have. Can I clear up something of a misunderstanding? This is essentially a resubmission of an application. There was a premises license, as you will have noticed, for these premises in the name of Abbey Meets Claude. And I think that the primary objection from the Bulmer Mews Residents Association is under a misapprehension that that was somehow different from this application. Mr. Munchies Limited took over that license and was trading under the Abbey Meets Claude license from November of 2024. And so what they want to do with the extension of hours, and I'll come to that in just a moment, but what they would like to do is essentially exactly the same thing. So you have a real-time test of this premises license between November of 2024 and May of 2025, and I refer back to the Environmental Health Officer and the report that you've just been given that there have been no complaints in the last 24 months. The residents appear to believe that that was an indoor-only license that only permitted indoor dining with alcohol served as table meals. That's not correct. And if you actually look at the outgoing license, and you've got a very helpful table that's been provided to you within your pack, at page 6, but if you look at that, you will see that the outgoing license was provision of late night refreshment indoors and sale by retail of alcohol on and off the premises. That's an off license. Now, the confusion in relation to the takeaway is that the indoor means that you can only consume indoors. That's wrong. And your legal advisor will help you with that if need be. I see that you're nodding already, but if you just take a look at Schedule 2, of the Act, you can clearly see that the licensable activity is supply. The supply takes place indoors, that's where the food is handed over, but it can be for consumption on and off the premises, and that's always been the case for Abbey and Claude. So essentially what this application is asking for is to do exactly the same thing as the previous license, certainly as the previous license permitted, and you've got the hours there, so you can see we're looking for half an hour difference through the week. So at the weekend, it's an hour difference through the weekdays and a little longer on the Sunday. That's the key difference, together with the removal of alcohol. because Abby and Claude had alcohol. That licence lapsed because the previous company went into insolvency, and so this company can no longer trade with that licence. But the difference is the removal of the alcohol. So I hope that clears a couple of matters up. Abby and Claude certainly was previously a takeaway. This is a vibrant and busy area. You will know it better than I do, and in terms of whether it is or is not residential, the noise of the road, and so on and so forth. But the main point that I would wish to emphasise for this applicant is that they're very experienced in running takeaways. The additional time that's been sought is not to turn this takeaway into some kind of destination venue with higher footfall. An late night refreshment licence is required for deliveries as much as it is for people actually attending the premises, and you will appreciate that. And even the additional few, there aren't many, but just for the additional few deliveries and walk-ins that may occur in the final half an hour or hour that these premises are seeking, can make all the difference. It's only in the matter of hundreds of pounds, perhaps, but it does make an enormous amount of difference. Munchies, Mr. Munchies Limited is associated with, it's a sister company to Cheat Meals, which is another name that you might be aware of that's been brought up. Cheat Meals has an outlet in Notting Hill. It also has a later outlet going till 2 o'clock in Earl's Court, and it has another 12 around London. This will be the third Mr. Munchies, and I'm pleased to report that out of all of those franchises, out of all of those venues, there are no complaints. There have been no reviews. The police have not sent in any warning letters. The police are, in fact, happy to work with both Cheat Meals and Mr. Munchies and the directors and the management of those because they're helpful and they're cooperative and they assist. So if things happen generally in the street that the police find disturbing or an issue, antisocial behaviour and that kind of thing, they can go to any of the Cheat Meals or the Munchies venues and obtain CCTV and staff help. And that, of course, would be the case with this outlet as well. And it can be of assistance, in fact, to have the CCTV condition and to have the staff vigilance and light in the premises and on the street to deter local crime and antisocial behaviour. The important thing for this business, as with so many businesses at the minute, is to maintain their viability and their sustainability. These are extremely difficult times. And although the council will have licensing policies and does have a statement of licensing policy, will also have business policies as well, trying to encourage your local economy, your nighttime economy, stimulate growth. We're about to have a budget in a couple of days' time, and businesses, as you know, and hospitality businesses, licensed businesses, are struggling in particular. So whilst it might not seem like a great deal to be able to trade for an additional half an hour or an hour, it does make an enormous difference for the viability of these businesses. They're not causing any harm or difficulty. The delivery element of it, I'm pleased to note, and I'll be corrected if I'm wrong, but I don't think the delivery element has been referenced at all in the complaints. I think people were concerned, residents were concerned about people moving around on foot. You'll have seen, of course, that there is a suite of conditions that's been proposed by the Environmental Health Officer. There was no hesitation in accepting those conditions to be added to this licence, and those deal to a large extent with the concerns that the residents had. So delivery drivers waiting inside the premises, for example, no noise outbreak, no smells, that would have been dealt with by planning anyway, litter picks, for example, and delivery times, etc. In fact, the Environmental Health Officer conditions are tighter than the resident conditions in terms of deliveries and bottling and so forth, or not bottling, there are no bottles for this premises, but the sorts of activities that can make noise mustn't start until 8 o'clock in the morning according to the EHO conditions. So it's a tight licence. The Environmental Health Officer is clearly happy with it, that it will control any potential issues. The police have had no objection. I think the fire brigade took a look at it and were happy with it, and there have been no other representations from any of the responsible authorities. So That would be the default position so far as responsible authorities are concerned, as your professional advisors on the likelihood of this licence application having an impact on the licensing objectives. You will know, of course, that if particular issues arise, and as I say, there has been the opportunity to test this in real time because these premises have been operating under this management between November and May of last year. But if there are any particular issues that arise as a result of the extension of this hour, then of course there's always the facility of a review. And then under those circumstances, the case would come back to the committee, either at the instigation of residents, the Residents Association, any of the responsible authorities, councillors themselves, to say, well, you granted that extension, it actually hasn't worked, and here's why. And then you would have the evidence specifically of what has gone wrong. But the licensing regime as a default, as a permissive regime, says yes as a starting position, unless it has to say no. And that's certainly something that's currently being encouraged by the government in terms of licensing regulation. That's a particular area that they have that they're looking at for growth, which is something that you may be aware of. I dare say your council and your officers have responded to the consultation. So I do commend this application to you. I hope that that assuages some of the concerns that the residents and the Residents Association may have. Picking up on a couple of things from the Residents Association objection, I think there was a concern also about opening times. When would be the closing time? That is built into the licence, as you can see on your table on page 6, because the opening hours to the public comprise the closing hour of the premises, the time that the shop is shut, and that is coterminous with the final hour for the activity. And that makes sense because that might be the last moment that a delivery driver takes away the delivery as well. So there is a hard deadline for the activities from the premises that's built into the licence, and I hope that is of consolation as well. I'm sure Mr. Kapalwak would be quite happy to talk to you about the experiences that they have of any of the other premises that they operate in terms of increased footfall or destination venue or any of those things, but that certainly hasn't been their experience. The additional hour simply means that they have that facility, particularly for deliveries, to allow those deliveries to be taken out and delivered to people's properties and homes at that slightly later hour, and makes the business that little bit more viable. I hope that has come in within the 10 minutes, and perhaps I can ask Mr. Kapalwak, do you have anything particular that you'd like to add?
Yes, sure. Hello, committee. Thank you for the chance for me to speak. I'm the operational manager for Munchies, and I'm also managing the cheat meals in Earls Court. And as my representative Sarah Clover mentioned, that we hold various licenses across RBKC, and we've not had any issues in terms of noise complaints or nuisance or any sort of issues with the council. Also in terms of, we've had an incident at one of our locations in Earls Court where crimes happened outside of our premises, and the police actually contacted us and wanted some assistance, and we were very forthcoming with that. We assisted them in supplying the CCTV evidence. This point was just, I thought I mentioned it because there was an issue mentioned in terms of it causing antisocial behavior, being open in the later hours. We feel it's actually to the contrary of that we would be able to assist with the local community in case if there are any crimes or anything of such happening. We are happy to provide our CCTV, and also being open in the later hours, a premises being well lit, in my opinion, deters crime, if anything else. Other than that,
thank you. 2 points of fact that the committee might find of assistance. The vehicles that the delivery drivers use are very highly predominantly electric. In terms of the vehicles themselves making noise, it is a lot of electric bikes and some electric vehicles, but that tends to be the trend. And then finally, in terms of employment, you might be interested to know that the 3 Munchies outlets and the 12 Cheap Meals outlets between them are employing some 20 to 30 employees, and this outlet would be employing and does employ 6. And again, I commend that to you as part of the local economy. Very happy to answer any questions if we can. Thank you.
Thank you. I will start with one question. Could you explain to me, there's a mix of going in, sitting down and eating, and takeaways. Could you kind of explain to me the percentage of people who will actually come in, sit down, eat a meal, as opposed to those that do come for takeaways or delivery drivers?
So in the later hours, i.e. after 11 p.m., the actual the percentage, I would say it's about 60% customers coming in and 40% of deliveries, but it changes depending on what day of the week it is, i.e. on weekends we would see a higher, slightly different ratio because people finishing from the pub and on the way home they might pop in and grab a takeaway. But I would say it's fairly equal, maybe slightly on the higher side of actually individual coming in and ordering and taking away.
Thank you. Councillor Wade.
Following on from that, in the previous licence, which has expired, was it a predominantly sit-down, i.e. you say now it's about 50% each? What was it in the past? How was the location used? Was it used predominantly people sitting down, or how much was takeaway?
Sorry, Councillor Wade, when you say in the past, how far past?
This is an application because a licence has lapsed. I just want to know, I need to know a bit more about how the location was used in the past. Was it predominantly people coming to sit down and eat, or was it always a takeaway?
So I can only speak from when we've took over, which was November of last year.
Can you speak into the mic?
Sorry?
Could you speak directly into the mic?
Yes.
It's difficult to hear sometimes.
I can only speak from the time when we have been managing it. So this is from November 2024. Predominantly, I would say about around 60% of our 60 to 65% is we rely on deliveries, and around 35 to 40% it would be individuals coming in, and it's mainly takeaway, and it's not very often we see customers actually wanting to sit at that late hours, so they come and collect their food and they're on their way.
Over the course of a day, because you're in a busy location during the day, do people, again, what is the proportion of people coming in and eating on the premises, and what's the percentage of people taking away?
Okay, so in our Pembridge location, we find it predominantly being very busy, that the eat-in and takeaway up until 8 p.m. we find that to be very, very busy because there's, people walking to the market.
So after 8 o'clock in the evening, it becomes more takeaway?
Correct, takeaway and deliveries.
So the balance, when you said 50-50 before,
Yes.
that was overall?
Correct, yes.
All right, after 8 o'clock in the evening, what is the percentage of people taking away, and and how many people are sitting down and eating?
Again, are you comparing it from eating away takeaway versus delivery, or just eating?
Yeah, it's delivery takeaway.
Okay, so it would say
either.
Yeah, sorry. I would say it's around 70% that people leave the premises, and around 30% that would actually sit down. This is in the later hours again. May I repeat?
Okay. I went there last night to have a look, and what is unique about this location is, one, it's quite difficult for people to park outside because the pavement's quite narrow. Also, that the location is just before I don't know what the name of the building is, the central building with the roads going on either side. Actually, you get residential after that, but you do have this Mews. So one of the things that I think concerns me is that if you have later hours during the week, when people are perhaps staying at home on Fridays, but actually during the week people are in the immediate area going to go to work, what mitigations do you think you could put to reduce noise nuisance, specifically by the use of delivery bikes?
Yes, please.
Just to point out that the hours for the previous premises were pretty extensive in terms of acid testing the impact. As far as deliveries are concerned, I certainly don't know whether Abby and Claude had deliveries in that way, but there have been deliveries between, certainly from November of 2024. And the way to control them is to have quiet vehicles and disciplined drivers. You'll have seen one of the conditions that the Environmental Health Officer wants in particular is that the drivers will come inside to wait. And the reason for that is that you don't have them on a bike or congregating outside, chatting, taking calls and talking to each other and making a noise outdoors. That's one mitigation that you see. But the other mitigation that all of these outlets can operate is to complain to the delivery providers, so the Uber Eats and the Deliveroos and those sorts of people. If you're having particular problems with drivers that are coming from those suppliers, you can make complaint direct to them, and they will either discipline the driver or they won't send them back to that venue again. So there is an element of control over unruly drivers. That's also something that the responsible authorities can step in with as well. So if residents are complaining about noise from deliveries, there are things that can be done about that. But to date, there haven't been any problems. I'm not seeing that as a major complaint in the residents' feedback.
I would say that this is a fresh application. It's an opportunity to look at it and take an opportunity to seek improvements. I think that in my ward, we do have problems with delivery bikes. And one of the problems that we have is that bikers come in anticipation of work. Many of the drivers are actually on multiple platforms. And therefore, when I asked about, you're seeking an additional hours, an additional time. And this, therefore, is, I realize you can ring up and you can complain to Deliveroo, but it could be they might not be using that platform. So those bikes potentially might not be there if your premises weren't open. So, I mean, I think it's an opportunity to create improvement. I mean, this is not trying to be confrontational. It's just trying to seek improvement.
That's completely understood.
Can I just ask, before you come back, I'll just ask, would the drivers be able to use the toilet facilities in the restaurant? Because that is key. I think a lot of the antisocial behaviour is people going into the Mews and using it as a urinal. So would they be able to use the toilets?
Well, firstly, if a delivery driver were found to be doing that, they'd be sacked. That's the first thing. Anyone who came to attention that was behaving in that way, that needs to be reported to, because they typically have some kind of badging on their vehicles or a plate or something of that sort.
Forgive me, that's very naive. We've had serious problems in my ward and in Earls Court ward with delivery drivers of all kinds of persuasions, and that simply isn't the case. And they do behave in a certain way for the simple reason they are going all day. They are people on, I don't know how they're employed, but they're not employed properly. They're paid a lot of the time per trip, and they're going all day and they haven't got anywhere to go to the loo, and that has been a problem. In my experience and in the experience of Councillor Wade, and we are very well aware of the problems that can come.
I'm I deal with the contracts between some of the delivery service providers and some of the retailers, and that would be built into the contracts. But be that as it may, in terms of what can this premises do, if that's a particular issue, they can certainly use the toilet to relieve themselves. If they're going in without a preordained order, that's part of the purpose of the condition that the EHO has ordained, that they go inside to wait to pick up the orders. If they go inside and they haven't got an order to pick up, they will be sent away again. And if that becomes a particular issue with a particular driver or a particular supplier of drivers, then that would be reported back to them. These outlets, these retailers do have an element of control over it. They can dictate which suppliers they'll work with and which ones they won't. I know some of the McDonald's have black net cordons around them so that particular drivers from particular suppliers can't pick up their orders on their devices because it's blacked out in a particular residential area. They have to go into the McDonald's or into the venue to be able to look at their device to see the number and so forth. So there are certainly things that can be done. McDonald's will have more resources in terms of digital and electronic blackouts and so forth, but it would be wrong to say that the outlets and the companies have no control over the drivers that do and don't go to their venues. And if there are particular things being reported, I wasn't aware, and I didn't see it in the representations, that it was drivers that were behaving in this way in Bulmer Mews.
I would actually say that I go back to the point about having an opportunity to improve the situation, and touching on that, and we've achieved this in other wards, that actually the litter pick could include Bulmer Mews, so that, I mean, we have a situation where we have multiple takeaways, and they have designated areas, and they pick up irrespective of whose waste it is, because it's a concession. And you would be looking at the detail. McDonald's closes at 12 there, and is on the main Notting Hill. So you are in a unique location, and where you could perhaps potentially become a contributor to supporting improvements of the area. So I would like you to consider that.
That is certainly true. It's also the case, although this is a new licence application, this is only a licensable activity between 11 o'clock and 5 o'clock. So you could have these outlets operating up until 11 o'clock at night on the face of it with no conditions whatsoever, and that's clearly suboptimal. And I'm not suggesting that the premises wouldn't do responsible community-minded things anyway, but in order to have any control at all, and we talk about improvements to the licence, in order to have a licence and any control at all, it has to go into licensable hours. You've got a licence here that has been operating up until 2:30 in the morning, and there's been no identifiable issue that's been traced back to those premises or that operation for those hours, even in the hands of this licensee, and that is what the responsible authorities are saying as well. Therefore, to curtail it would be not in the spirit of the licensing act and regime. And when one talks about extending it, one would then have to ask, well, what is happening between 2:30 and 3 that wasn't happening between 2 and 2:30? Because obviously a license has to be granted on the basis of evidence. As far as toileting is concerned, control over drivers, litter picking, I have no doubt whatsoever that these premises would wish to be supremely community-minded. When it comes to going up and down the streets for litter picking, however, one has to be very careful about doing that in the nighttime hours, because that then starts to trickle into health and safety and insurance issues. If you have members of staff, particularly female members of staff, vulnerable members of staff, that kind of thing, going up and down the street, going further and further away from the demise of the premises where they work in order to go and pick up litter, and I'm not suggesting for 1 minute they wouldn't pick up other people's litter, of course they would, all responsible outlets do that. McDonald's is a trend setter as far as that is concerned. All of the good premises will do that. But the further and further away you start to go from the premises themselves and starting to do a community litter pick, the more at risk potentially those members of staff are, and that can become a problem in and of itself. And that's why your environmental health officer will have identified the area that they have done. Litter picking earlier in the day would not necessarily be so much of a problem because of the light hours, and I have no doubt that the premises would do that voluntarily so far as they may. But you can't mandate it in the hours of darkness because that causes a problem in itself.
But I would also say that residents are apprehensive about what they see is a series of applications coming forward for increased hours, which are changing the character and the context of the area that they live in. And
May I come back on that specifically?
Therefore, I think it's more about everybody wants to have good business. But actually, it's a point where you've got to see whether on the businesses actually consider that they have a responsibility to the area that they're operating in. And that's where this is a conversation about how we take this opportunity of an application for a new license to seek improvements that benefit both the business and the residents.
Completely understood. That's quite understandable. As far as precedent is concerned, I've no doubt that your legal advisor will indicate that that is not a licensing consideration. To say, well, these operators, this applicant cannot have the hours because others might apply in the future, that would not be a lawful approach. So far as community-minded is concerned, that is certainly true and quite overtly something that this company would wish to do and does at their other venues. And that, again, is an acid test proof of the pudding, because the police department speak together, environmental health officers can make inquiries if they wish to as to how premises have been managed elsewhere, including the ones within their own area. I've no doubt that your environmental health officer will know the munchies or the cheap meals rather at Notting Hill. But in terms of seeking improvements, if the premises are operating satisfactorily and have caused no identifiable problems, and that's the issue, it's an evidential issue, if they've caused no identifiable problems trading up to 2:30, the question has then to be, what will the additional problem be between 2:30 and 3 in the context of the council's ability to have a review of something specific that has happened. So this is the difference between belt and braces saying no on a just-in-case basis and saying yes with the caveat that if it does identify particular problems, it will be taken away again, and there's nothing wrong with doing that.
Move on to our legal officer. Do you have any questions to ask?
No, Chair, no questions.
So I will now go to the objectors. Are there any questions?
Sorry, Chair, if I may interrupt. Apologies. Just to make you aware that we're currently seeking some clarity on the late night refreshment indoors and outdoors aspect. I'm hoping to have a response from legal very shortly, and I'll update you then. But for the moment, we're just seeking some clarity on that definition, just to make you aware.
It's on the Poppleston Allen website, if that helps them.
Thank you.
And we have already raised that with our legal officer, so we are aware, but thank you for looking into that. Objectors.
Thank you. Could I ask, given it's a double yellow line between the traffic lights and the roundabout, and then it's zigzags from down the rest of Pembridge Road, where do you think your courier drivers are parking? I.e., do you think, as I could prove with CCTV, had we realised you were actually doing midnight takeaways, that they are parking in our Mews entrance, because that doesn't have any zigzags or double yellow lines?
It's a little difficult to comment on specific evidence that's being brought in the middle of the hearing. I'm afraid I don't know where they're parking. I was under the impression that they were using bikes predominantly.
But they're still not allowed to park on double yellow lines, are they, or zigzags? Nobody's allowed to park on them, whether you're a bicycle. If
Well,
you're on the highways, you either got your bicycle on the pavement.
I'm not in a position, regrettably, to respond to evidence that's being brought in the middle of a hearing that isn't actually being brought. If there's CCTV, I'm afraid that should have been served. I don't know anything about it.
I'll make it clear in our speech.
Sorry,
but
shall
I'll
we
make it
just,
clear in our speech.
I think the point of the question is perhaps it'd be easier to say, if the license were granted, where would delivery drivers put their vehicles?
Well, delivery drivers are required, like everybody else, to park and drive legally. If they're not doing that, then something needs to be done about it. But I can't comment preemptively about what would happen to a driver that's not parking legally. Do you have
So
any further comment?
can I ask, as a follow-up,
To be honest, my question would be, where did I park prior to 11 p.m.? So yeah, I
and
understand.
what are you doing about it?
I mean, in terms of the way, I'm sure you've seen our location, where we are in front of us, there's like the metal fence, and then there's the bollard. So we haven't actually got, there's not, what is it that you thought that we could do about it, where, you know, in terms of, you know, the housing association, where we could, you know, we're happy to, if you've come up with a solution, we're happy, because there is literally nowhere where we can, you know, put lines up or put like parking there. It's a main road, and there's a roundabout, there's zigzag lines, and we assume as a business that these drivers park in you know, across the street where there's parking, and then they would walk and collect. But again, it's if they do that or they don't do that, we have no control over where they park and where they don't park, and I'm assuming that would also happen before 11 p.m. as well.
Can I just point out that these are premises that have at some stage been given planning permission to be there as a restaurant and a takeaway outlet. They have been licensed since I don't know when, apparently for a long time, to be a takeaway outlet, and have not been reviewed. And this, as you've rightly pointed out, is another opportunity to review review the grant of a license. The environmental health would have something to say about it, planning would have something to say about it, and the police would have something to say about it if these drivers were de facto causing illegal parking issues, and they're not. So to have that evidence sprung in the middle and say, actually, there is illegal parking, but we don't have any evidence to show you, would not be an appropriate way of pursuing a licensing hearing. If that becomes an identifiable problem and evidence is brought forward, then, as I keep saying, that could be the subject of a review application.
So may I add? If I also may add, in our Earls Court location, Cheat Meals this is, the council have got now designated areas where drivers come. I'm sure Councillor Wade is aware of it. There's designated areas where the council have designated those areas where drivers have to park, and then they walk to that location. So perhaps something similar ought to be, you know, planned in future for the Pembridge Road location. So businesses that are facing the same issues that we are, where there is no direct access from the road, and, you know, maybe have designated areas for drivers. But that's something, you know, for the council.
I mean, I think I quote you back that you say that there is no area outside. They are coming to your restaurant to collect. There is no other restaurant in that street for takeaways late at night. And as you said, they're parking opposite. And opposite is us and the service road. And that is why we have a problem.
Apologies, you'll have an opportunity to make submissions.
Well, actually,
this
no,
is more
I was
if
going
there's
to,
a question.
I was actually going to ask the next question, which is actually that they are coming to your property, your premises, to collect. They aren't in our control. They're much more in your control than ours. So I don't understand what you are currently doing to move them on or to stop them from parking illegally.
I think the answer to that is the one that's already been given. There is no awareness from these premises that illegal or antisocial parking has occurred. If that is evidence that's being brought in the middle of this hearing, then I'm going to invoke Regulation 18, I'm afraid. I have not identified in the representations that have been made that this is evidence that any representor wishes to bring forward.
Okay, thank you. Councillor Gardner, have you any other questions? Or any of the other objectors, any other questions?
So this is actually a question for the committee rather than for the applicants. It's actually whether I'm correct in understanding the onus is on an applicant to demonstrate that a licence should be granted, not on either the council or the objectors to demonstrate that it should not.
It's for the committee to consider what would be appropriate in order to promote the licensing objectives. You're aware that the 4 licensing objectives are prevention of crime and disorder, prevention of public nuisance, protection of children from harm, and public safety. So the committee will consider everything that's been said by the applicant, by you, and consider what's most appropriate in order to promote those objectives. I don't think I can explain or say anything more.
Are there any further questions from the objectors? Okay. So we will now come on to your case. Councillor Gardner, Richard Everett and Jane Johnson, you each have 10 minutes if you wish to speak. So, Councillor Joanna Gardner.
Thank you. I represent all my neighbours in Bulmer Mews, which is diagonally opposite the premises. 2 of the neighbours who objected, but can't be with us today, can actually see the premises from their bedrooms where they sleep on the top floor. Top floor is the nicest, with a wall of glass, 2 windows and a patio door, and they often sleep with all of these open. Hence, they're particularly concerned about the proposals in this application to open daily till 2 a.m. and on Friday and Saturdays till later, i.e. 3 a.m. I had actually, and this goes to the very heart of what we're here about, our understanding is that, and this is on which our written objections are based, that this application does not state anywhere that this is for late night refreshments that can be consumed off the premises. I even asked Mr. Pullen earlier, and I also went and asked Mr. Mahaffey about this, and he said, I appreciate it's now off for clarification, but we were only talking about food and hot drinks being eaten on site, as shown in the red licensed area. If the applicant wants to provide service and food for eating off site, then they need to reapply for that. And our objections would have been very, very different because we pick up the rubbish daily. We've got CCTV columns which show people peeing in our mews, which shows courier drivers peeing in our mews, which shows people coming and buying a takeaway and then going and buying a beer and sitting in our mews. So frankly, we do have massive issues with both the noise, the nuisance, and literally people eating on our doorstep. And when you wake up in the morning, there's people who've had a party out there, and the public safety if you're coming home and at night. But frankly, this premises had never had a takeaway licence. It's always been VQ, which was a sit-down restaurant. It's always been Abbey Met Claude, which was a cocktail bar with food. And the requirement was always eat-in restaurants with food on site with alcohol served with meals. The bike riders, we have them constantly parking up in our mews. You know, I walk past them and say, are we providing free parking for you? And they all just tell me to F off. So, frankly, what we have objected to isn't what the applicants are saying they've had. Okay, so they've been open from November to May. That hasn't been real winter time, and they've had slow growth. It's not even been summer. When you hear about the hours that they want, this is very much a secondary location. It doesn't have other premises. The latest that something's open is till 12:30 to serve alcohol next door to us. That's it. And so, frankly, I wanted to talk to you about 4 things today, but it wasn't about takeaway because, frankly, we read this as indoors. We know VQ. We sat down and we negotiated with VQ that they weren't going to have midnight licenses and they weren't going to do takeaways. So the courier was to cover an hour. VQ never had takeaways, neither did when Abbey Met Claude. So this whole proposition that we're here on and that they're here on are different. And that is where I sought clarification, and I haven't had the clarification yet. And unfortunately, it only came in when the conditions came in, and that was Friday night. So I want to talk to you about the substantial later hours. I wanted to talk to you about the absence of controls of any people eating burgers on site. I wanted to talk to you about cooking right up until the late night hours. I also want to talk to you about all the doors and windows being closed after 11 p.m. And I wanted clarification on the licence that there was going to be no courier or delivery services at an indoor licence only premises, because that's how this has operated for years, except for 6 months. So I really hate being beaten up around my head on this basis. So let's have a look at those hours. We appreciate that this was a grandfathered licence. We do, however, feel there's mission creep here in seeking longer and ever longer opening hours, irrespective of the fact that residents are trying to sleep. So 2 a.m. 5 days a week and 3 a.m. on Fridays and Saturdays, which is far in excess of the previous tenants, and they even pushed their hours later. Pembridge Road is very much a secondary shopping parade. It's surrounded by residents like us opposite. It's got residential flats above it all the way along Pembridge Road, and as Linda commented, as is also in my photographs, it's residential on either side of the roads. So what you are actually doing is you're encouraging footfall into an otherwise quiet area late into the night, and with it the noise nuisance that comes with it. And now we're being told, yeah, and you can take the courier motorbikes, you can take the rubbish, you can take the peeing and the music. I can tell you it's really offensive when I come out on a Sunday morning. The number of people who've peed in the mews is just horrifying. So instead, we ask that you restrict this to 1 a.m., to Monday to Saturdays and midnight on Sundays. That's a balance to allow some late night trade, but also respecting residents and sleep. And it also fits with the midnight policy. It will still be the latest burger place in the area that's open, even with 1 a.m. hours. And they're already opening an hour earlier at 8 a.m. than the previous occupiers. If we really are talking about an on-site indoors licence, not takeaways, then we say, how are they controlling those people who are going to eat in? Because we don't think that works. I don't even know if it's even worth my time wasting my energy to talk about this, given until we have clarification on what sort of licence we're talking about. And thirdly, how you can cook right up until closing time. I didn't understand that if you were only going to be eating on site. Fourthly, I'd like to be clear on the licence via condition that all doors and windows will be closed from 11 p.m, except for access and egress by customers through the front door, as it would help lessen noise, smells, cooking and customers, and potentially these courier drivers, particularly given my neighbours sleep with their windows open and their patio doors at the front of their homes. And then I also want to talk about this being only an indoors late licence. We might like to make it clear on the licence with an express condition that after 11 p.m. there are no takeaways, no couriers, no delivery services, and that conditions 1 and 10 as proposed should be amended to reflect that. Essentially, we are talking about a premises that has historically, and I've lived there 30 years, through VQ, through when Abby met Claude, they have always been restaurants which serve alcohol, and the meal, and it's always been, that is actually one of the reasons why we haven't really kicked up the most major fuss with all the previous premises, is because they never did do takeaway. They were premises where you came and you ate on site. Takeaway was never an issue. And that is why, as a clarification, this whole thing, it suddenly dawned on me last night, are we here talking about a licence that allows takeaways? Because I can tell you, our evidence would have been substantially different, but there is nothing, when you read the application, there's nothing on the application to say this is for takeaways after 11 o'clock at night. It merely says we offer takeaways as a business. It doesn't say from 11 till 3 a.m. And frankly, that's why we're all here. And if we'd known, we would have given you massive, massive objections. We also, my neighbours, had they realised that actually those motorbikes were Munchies, because they're not going to come downstairs from the top floor, wander out and see and say, excuse me, where are you delivering from, or where are you collecting from? They don't go out at midnight or 1 a.m. across the road and go, I didn't know Munchies was doing collections or deliveries. You know, you're going to roll over. It has to be the whole question of review really is unhelpful, because actually that involves a resident almost camping out to actually sit there and go, sorry, where are you delivering from? where are you collecting from, where have you got your burger from or your drinks. We see the Munchies paperwork in the morning when all the litter is thrown in our mews. What I don't do is come down when somebody's drinking a beer with their Munchies and say, excuse me, can you move off? Because frankly, from my public safety, from my kids' public safety of walking in the mews at night, it's not a place you want to go in. And so to expand that to 3 a.m., if not 2 a.m., basically every day of the week is just a shocker. So I'm sorry, my speech isn't exactly as I prepared it, because we seem to be talking at cross purposes about what we think this licence is about. And when I have sought clarification, I haven't got it. But this has previously always operated as a restaurant. Thank you.
Before another objector speaks, just to say, for clarification, Joanna, when I first read this pack, I saw it as a takeaway venue. That was my first understanding of it, having sat on licensing for many, many years. The first thing I did when I came in today, because I realised there was also a misunderstanding, was to seek clarification from our legal representative. So I think I'm going to turn to him now and ask him to explain. When I read it, I knew that takeaways were involved, or that's what I thought, but I had to seek clarification because I thought there had been a misunderstanding.
Yes, the application includes takeaway, or it could include takeaway. If late night refreshment is granted until 3 a.m., there's obviously it's up to the license holder whether that includes delivery, takeaway or not. The licensable activity of late night refreshment or providing late night refreshment is defined to get technical, in Schedule 2 of the Licensing Act. And it's the supply of hot food or hot drink to members of the public or a section of the public on or from any premises, whether for consumption on or off the premises.
Can I ask, as a point of clarification, it dawned on me last night that this was a possibility, so I saw clarification of it this morning, and again the officers have said to me it's not clear. Certainly in the past it has never been used for takeaways, and I also struggle when I actually looked at the council's licensing guidance, that for me, for a layman, because I have never sat on licensing in 22 years as a councillor, it is not clear what the distinction is between indoors licensing. And it should actually, in your policy, say indoors means for consumption off-site as well. Because frankly, what's the difference to a member of the general public between indoors and outdoors? Outdoors, you read it as eating it outdoors.
I think we have to accept the legal advice that we get, but I'm going to call in Mr. Feeney again.
No, that's, well, just to say we're here to consider this particular application, and so the committee has heard what you've said, in particular that it hasn't been used as a takeaway before, which can be considered, but I think we need to focus on what's been applied for.
Could we ask for an adjournment so that we could actually then submit additional photographs and evidence, given the fact that this is not the licence that we understood, and nobody, when we submitted our objections, pointed that out to us?
Well, we would not be able, in order for you to provide new information evidence at the hearing, under the licensing hearing regulations, that would have to be, I'd need to check the regulations.
It's 18.
I think it's disingenuous of the applicant not to state in their application anywhere that they were doing takeaway and they were planning to do takeaway, nor do they even talk about how they were going to control courier drivers. There's nothing in those conditions that gives you any implication that they are looking to do anything off-site. And frankly, after VQ for 10 years and when Abby met Claude, I don't see why we would be expected, because they had indoor licensing, why we would be expected to know that it was any different.
can't accept that. As the legal advisor for the applicant, that is fundamentally misconceived.
Can I just come through with something, not being a lawyer, but I think the indoor-outdoor is the distinction between inside the restaurant or tables and chairs and etc. outside. That is why it's indoor, because you go inside to get whatever, the burger, and then you take it out with you. And I think that is understood. Okay, I'm going to go...
Maybe by yourself through guidance, but literally as a member of the public who's never sat on licensing, I suspect you'll find all of us view that indoors means you buy it and you eat it on indoors.
But with respect, Joanna, we have to look at the licence that is applied, that is in front of us. Now, I have sought legal opinion as to what that means, and I have been told that that also means takeaway. That's why we have legal advisors. So I am a lay person again in that sense. So that is why I sought clarification the moment I came in this morning, and I received the answer that I received. So, Mr. Feeney.
I think we need to move on from this. I understand you would like an adjournment to provide additional information and evidence. Under the regulations, the committee can accept further information and evidence at the hearing, either if it's provided before the hearing or with the consent of the other parties at the hearing. So we'd need to get the applicant's views on any adjournment and provision of additional information. So I suggest that we do that first. Then I suggest that the committee adjourns for a short period just to consider the request, and then we come back and make a decision on that and then go from there.
Can I just make a point, a question? I'm a lay person. I have no legal experience, but I have come to the licence committee numerous times for the various premises around us. I've sometimes questioned when, regarding an alcohol licence, why people were applying for an outdoor alcohol licence when basically they didn't have tables and chairs outside. And I was told that they needed an outdoor licence in order to take the alcohol off the premises. So if they hadn't finished their bottle of wine and wanted to take it home, they had to have an outdoor licence. Why isn't it the same with food?
That is correct, but that is for alcohol. That is my understanding.
But it's
and as
different
I've
for
said,
food.
we have to be guided by our legal officers in this.
Like I said, I think if you would like to maintain the request to provide further information and evidence, would you like that opportunity? That's what you're asking for.
The answer is yes, but
Well, in that case, we need to hear what the applicant says, and then the committee will, I think it would be helpful to take a short adjournment just to consider that request.
Can I ask, have you also got the clarification from legal Mr. Phelan was getting? Because that was the very first question I asked him before this meeting this morning, and he said, sorry to misquote you, but he was also seeking clarification because he had thought it was indoors only.
Mr. Feeney is the legal advisor for this hearing. We can get clarification from other places, fine, but this is, the licensing authority. We are sitting in, a subjudiciary capacity, and our legal advisor is Mr. Feeney. Okay?
So I suggest we go to the applicant now just to respond just on the issue of whether you would agree to the provision of further information and evidence at the hearing.
Well, I'm pleased to confirm that I've been a barrister for 32 years, and licensing is my speciality, and I'm a fellow of the Institute of Licensing, so I'll be very happy to provide any clarification as required on the law. It's regrettable if laypersons don't understand the law, although they always have the opportunity to go and inform themselves prior to a hearing if that is what they wish to do. The provision of late night refreshment, by definition, is a takeaway licence. That is what it is. And I see shaking of head. I would like to pull rank on that. No, I do not accept an adjournment at this stage to go off and get further evidence, and the case law on that is Matthew Taylor and Manchester City Council. So I would invoke that to start with, as well as the Premises Licences Hearings Regulations 2005, Regulation 18. I absolutely stand on those. It would be unconscionable. In fact, it would be judicially reviewable to adjourn at this stage for the reasons being requested, which fundamentally is a misunderstanding, a lay misunderstanding of what the law is. That is not the step of the applicant, and I'm taking this stand on behalf of the applicant as a lawyer, because it's very important that these proceedings are not legally derailed.
Okay, thank you. I think in the circumstances, I think the best approach would be just to continue with the objectors' representations, Chair, unless you would like to adjourn and consider anything further.
Councillor Wade, do you feel the need to go into private session to discuss?
I wouldn't mind if you don't. I think it might be a good idea.
Okay.
All right, so the committee is going to adjourn just until for 15 minutes, just to consider the request and the response, and we'll come back with a decision just on the request and the response. Thank you. So we'll be back at 11:33.
Can we please be upstanding for the committee?
Thank you all for your patience. I will now refer to Mr. Feeney, our legal advisor.
The committee has considered a request for an adjournment from the objectors in order for the objectors to provide further information and evidence at the hearing today. The committee has decided to refuse this request. Under Regulation 18 of the Licensing Hearing Regulations, the authority may take into account documentary or other evidence produced by a party in support of their representation, either before the hearing or with the consent of all the other parties at the hearing. The applicant has not agreed to the provision of further information and evidence at the hearing today. It is unfortunate that the objectors misunderstood the scope of late-night refreshments as a licensable activity, but the committee considers that it would prejudice the applicant and be contrary to Regulation 18 to adjourn to allow for the provision of further information and evidence at this stage. So we're going to ask the objectors to finish making your representations, please.
Thank you. I think so far this illustrates the difficult task that you as the licensing committee have to balance between demands of business versus the well-being and needs of residents. This is an opportunity to look at the license for this premises, which is an outlier in the area, and redress the balance between commercialism and resident well-being. The number one issue for residents in the Notting Hill Gate area, as evidenced by surveys done by both the Council and the Metropolitan Police, is the increasing incidence and impact of antisocial behaviour, such as noise, litter, and intimidating behaviour, especially late at night. We in Bulmer Mews have had a long-standing problem of people using our quiet but easily accessible mews to eat and drink their purchases, urinate, and sadly on many occasions far worse. Late openings of premises that sell fast food and the added access to alcohol from shops in the area has made the problem of antisocial behaviour worse. And we look to you to protect our environment and our health and well-being by ensuring that we get some respite from the footfall, street traffic and noise late at night, and thereby give us a good chance of a reasonable number of undisturbed hours of sleep. Notting Hill Gate and the Pembridge Road area, although extremely busy and noisy during the daytime, significantly quietened down in the late evening, especially after 11 o'clock at night, both in terms of footfall and road traffic. This application, which is a new application for a licence, drives a coach and horses through this peace and quiet, especially if these late hours are going to include not only customers eating in the restaurant, but also customers who purchase takeaways and food delivery companies picking up orders into the early hours of the morning, 7 days a week. Noise carries much further in the night, both from voices, the revving of cars and motorbikes, and the opening and closing of car doors. Noise associated with takeaway from customers is worse from takeaways than it is from customers who eat in. And the figures that Munchies has given us this morning show that later in the night, their custom moves from being mainly eat in or partially eat in to being much more take away. The temptation for Munchies customers to pick up a takeaway, cross the road to get alcohol from the shop on the corner of our mews, and then picnic in our mews is already happening, as evidenced by the rubbish that we have to pick up. none of the measures outlined in the application by what is a limited number of Munchies staff on duty at any one time are going to stop this from happening. We don't want to see strangers in our mews in the early hours of the morning, not just because it is a nuisance, but because it is also a rather threatening safety issue. This application is an outlier for the area. Pembridge Road is a secondary road and much quieter than Notting Hill Gate. All other fast food outlets in the Pembridge Road area close by midnight. And on Notting Hill Gate, which is a busier road, Cheat Mills closes at 12:30, while McDonald's and the chicken shop are both earlier. To allow this premises to be an exception with a closing time well into the early hours of the morning, 7 days a week, in excess of what it had and what other similar premises in the area have, is unacceptable, and the application puts forward no good reason that fulfill the licensing objectives to allow this application to go forward. This application is a clear case of mission creep for the area, encouraging other fast food and takeaway premises to apply for their hours to get ever longer and later. Where Munchies might lead, others will follow, and the balance of residents' needs versus commercial interests will become irrevocably worse. If, as I understand it, you judge each case before you on their merits, it is irrelevant to compare Munchies to previous occupants of this site. Manzara, VQ, when Abby met Claude, were all sit-down, waitress service restaurants with no takeaways, so a completely different kettle of fish to what is being asked for. And please don't tell me that a license can always be challenged if problems or breaches occur. That, from my experience, is a fantasy. Reporting breaches to the council is, I'm afraid, too bureaucratic, time-consuming, and usually goes nowhere. And contacting the police for more serious antisocial behaviour problems in the current personnel numbers and state of the Metropolitan Police is pointless. As a new licence application, we would prefer to see the council's midnight policy adhered to, but if we cannot achieve that, then we ask that closing hours for indoor late-night refreshments, including takeaways, are limited to 1 a.m. Monday to Thursday, 1:30 a.m. on Friday and Saturday, and no later than midnight on Sundays. I concur with my neighbours that takeaways and delivery service pickups should be limited to the hours up to 11 p.m. Customers leaving the premises with takeaways and the coming and going of couriers and delivery drives after 11 p.m. when the area is quiet is extremely antisocial. Thank you.
Do you wish to speak?
Madam Chair. Thank you, Madam Chair. Just a few points. I do, of course, share the concerns about the hours and reiterate the Bournemouth Mews residents' legitimate expectation that the council would adhere to its policy on hours, absent some good reason. Is that better? I think this microphone, I have to get very close to it, do I? Just to say that I would also endorse the other residents of Bournemouth Mews' views that their legitimate expectation for the council to follow its opening hours policy for licensing, subject to there being good reasons. And in this case, I think the residents of Bournemouth Mews do accept that it may be relevant for the committee to consider the hours that had been in place on previous licenses for the same premises, but there are no good reasons put forward for extending them. Might I also, parking that point on hours, come to the conditions that have been put forward. There are a few aspects of this which cause concern whether they are in fact sufficiently tight, given what we've heard today. In particular, in the first proposed condition, it should be any person waiting to collect food shall do so inside the premises, so we do not get the possibility of people congregating outside, vaping while they're waiting for their takeaway and chatting noisily to the detriment of local residents. Appreciate that couriers may be a more chummy bunch than that, but people coming out of the pub, crossing the road to get a takeaway, perhaps adding to it from alcohol from the local shop, we'd rather they weren't gathering outside and disturbing those who are trying to sleep in the mews. There shouldn't be smoking outside anyway, or vaping, I think. The access to the loo that was mentioned before for couriers, I think that should be applied ideally for any person waiting for takeaway, not just couriers. It's probably easier for the operators or the staff at the shop actually to say yes or no on a more general basis, rather than trying to pick and choose as to who's a courier anyway. But yes, any person waiting for a takeaway shall be given access to loo. Condition 5, not just the area in front of for collecting litter, not just the area immediately in front of the premises, but in the vicinity or something wider than that that would ideally cover us. Another condition 10, and
I think we have a specific section at the end which is just about the conditions.
if you'd like me to return to this later, but yes, this is. Oh, someone's turned the volume up. Thank you. Then we're quite happy to come back to it then, but I've only actually got one other thing about what's missing, I think, which is about dispersal of people so they don't gather outside. But if you want detail of the conditions later, I'll come back to that. Sorry. And also about, I think the contents of the policy can refer to in condition 10, potentially including things like where delivery bikes are parked. Yes, sorry, I'm having trouble with the microphone. But yes, I'm happy to come back to that later if that's more helpful.
So now we will turn to questions from the committee. Councillor Wade.
Personally, I have a lot of sympathy experiencing precisely the same problem and the lack of, shall we say, community engagement. It's quite clear that you've got a problem on a number of different levels. Would you consider having a resident engagement with the business in order to be able to, say, every 6 months, so you can actually collect your evidence and then have a meeting with them, and if that's not resolved, you'll be able to take it forward. Is that something that might interest you?
I mean, we can do so. We offered twice over this application to meet them, and we got nothing from them. So I'm slightly dubious about the impact of it, but our door is always open, yes.
Yes, but if it was made a condition of their licence, so they would have to comply.
Yes, always helpful. Thank you.
One of the questions, given the immediate location, what's the impact of the pub then? Because you've got a number of businesses that finish probably about 11 o'clock, and so could you kind of just elaborate on what is the difference between the closing time of the pub and the closing down of this business in the immediate area where you live?
So the pub, actually, we get on very well with them because their service delivery is through the back, so we share the entrance road. They stop serving at midnight, and so all their the garden at the rear is shut from 9 o'clock at night, so we get no noise at the back. All customers go in and out through the front door, and essentially they're very well run. They keep all the noise to the front, and they disperse. They have a dispersal policy. They disperse towards Notting Hill Gate. So actually we had a meeting with them just last month. They do 6 monthly meetings with us just to chat through issues. Never a problem. The shop on the corner is a little bit more of an issue. They have a 12:30 liquor license, and we do find people buy from there and sit on the steps or bring their beers in, supplemented by munchies. But that is only one shop in the whole area. So literally that's the latest, 12:30 in Pembridge Road. Munchies being, as Jane said, the outlier. So on a relationship basis, we get on well with all our neighbours. Munchies is the only one that really hasn't been working with us.
Do you have a bike loading bay close to the premises? Because I was trying to look around last night as to where people could park, and I couldn't remember whether or not there was an available space for bikes to park.
We have e-bike bays, yes. There's one outside Kensington Temple. In terms of formal loading and unloading bays, I don't think that's something we expressly have as a provision in the ward generally. I don't think it's ever been, we've never been approached. Certainly I as a ward councillor have never been approached for one either.
It was just, I think that what might be useful is if on the app, whether it actually kind of states where the closest parking area might be as part of the, you know, the pickup information. Something you would, do you think that might go some way towards the bike?
I mean, anything that puts them on the other side of the road is helpful, yes.
All right, so because, no, on the apps you can either stop the app in a particular area, but it's also that, for example, you can add information to the driver saying, would that be something that you would look to see?
If it keeps them on the main road, on Pembridge Road, on that side of the road, yes, that would be helpful. Certainly I know outside Notting Hill Gate, sometimes we get 14 motorbikes sitting outside waiting, as you said earlier, just in the hope that McDonald's will give them some jobs. So certainly from our perspective, anything that keeps them away from the Mews and the residential streets would be welcome, yes.
Perhaps as a councillor you might like to talk to Highways and see whether or not they could make a provision, because McDonald's has takeaways, other places have takeaways up to 11 o'clock. It might support an improvement in the area. I'm just saying, I'm not saying it's a total solution, but it's something that is going halfway, because we must acknowledge that things have changed since COVID. The increase in bike deliveries, bike-dependent food distribution has changed, and perhaps that just hasn't kept pace.
Can I ask just one question? So obviously you've experienced difficulties, but since November 2024, there haven't been any complaints. So, you know, when we look at it, there are no complaints, and yet you come and tell us your complaints.
Yeah, it's catch-22 because we had complaints. We didn't realise that Munchies was doing takeaways. So do I turn around and go, if I look at the CCTV camera, because there is one on the entrance to the Mews, yes, I could daily flag you things. I could flag you things during the daylight hours every single day. But I didn't realise that Munchie was the offender. I have better things to do with my life than either be reporting them daily via the Reported app, or to actually be going across to Munchies and saying, by the way, we saw that this guy tracked across to yours. Because actually I probably can't do the link. I would probably have to be, or indeed any of my neighbours, we'd probably have to be physically there to actually look at it and go, that bike was parking there for Munchies. If I sat down and actually thought it through and looked at it and knew that Munchies was open until whenever. I mean, to be fair, they've only been operating till 11 o'clock since May. So actually, as a result, none of those motorbikes would be pointing that direction. I think they did have a slow start in November. And I know those in the houses directly opposite, they're not of the age where they would be getting out of bed, dressed and going downstairs to have a look at whether that thing that woke them up was... Because usually, often, by the time they've gone, by the time they will have done all that, the perpetrator of the noise nuisance will be gone. And also, I can tell you, I wouldn't want to be going downstairs to be met by 3 people eating burgers outside, because often they're not sober. It's not a situation on a safety aspect that you'd want to be putting yourself in. And who do I then report it to? So I open my door, and there's 3 guys eating burgers outside. Where am I reporting that to? Am I going to say to them, by the way, where did you get your burgers? It's the difference between the reality of the noise nuisance complaint line or the complaint line and how it works in reality, that people aren't really going to trot downstairs, open their door, take a photograph, and then submit it. It's not really how it happens, reality. Sorry, did you have anything?
Okay, thank you.
Sorry, just one thing to add, following on from what's been said. I mean, much has been made of the absence of complaints about Munchies, but as just been pointed out, the reality is over the 24-month period being cited, they've not actually been operated during the extended hours, so there is no evidence either way, frankly, as to whether or not complaints would pop up.
So I will go now to our... Do you have any further questions? No. Okay, I will go to our legal officer, Mr. Feeney.
No questions, Chair.
So I will go to the applicant, Ms. Clover.
Yes, thank you, Chair. I'm sort of picking up where you've left off, really, on this business of, Councillor Gardner just said, we didn't realise Munchies was doing takeaways. And I think a colleague just said, well, of course, Munchies wouldn't have been operating to the extended hours. So I'm seeking some clarification as to what the residents did or did not know, because Munchies between November of 2024 and May of 2025 were trading to the full extent of the licence of Abbey and Claude as it extends to late night refreshment as per page 6. So 1 o'clock Monday to Wednesday, 2:30 Thursday to Saturday. And so I'm just seeking that confirmation that the residents did not know that Abbey and Claude had changed to Munchies in November 2024 and were trading the full extent of that licence.
I think I merely reiterate that it was a slow start for them, and it was also the winter months.
That's not something that lies in the mouth of a councillor to say. Munchies will know what level of trade they were doing. What I was seeking confirmation of was whether the residents were aware of that switch from Abbey and Claude to Munchies at all.
I think visually you can't miss it, but I have to admit it's because it's physically changed outside. Did I know they were doing takeaway? No.
The follow-on from that then would be if residents are not going downstairs to investigate a noise nuisance or a disturbance of some description, what is the connection between what is being perceived and somebody who is coming from Munchies, whether it be a customer or a driver?
So it's the rubbish in the morning that we're going around and collecting that isn't there when we go to bed. There's the motorbikes that I can see on the CCTV camera. There's the timing. So I could, had I known that this was a takeaway and this was also what this application was for tonight, because as we've said before, Manzara VQ and When Abbey Met Claude did not provide takeaways. They were eat-in venues. Then I could probably have tracked it all back to Munchies if I had sat down and done a lot of more work. I would have provided that evidence. I was not given that opportunity because of a fatal misunderstanding. So yes, we probably could have been layering in the complaints. We probably also could have been tracking them back. I mean, I could give you the Munchies packets. I can give you the wrappers. I can give you the little paper trays because I'm physically collecting them in the mornings.
I wanted to clarify, I only have a couple more points, if I may, through you, please, Chair. I just wanted to clarify who it was that Councillor Gardner said she'd offered to meet twice, because that isn't something that Mr Kapalwak is aware of. So who was it approached at Munchies to meet?
So I went through governance. We offered to meet you over this settlement. I asked governance to drop you our email address. I also wrote, so firstly I wrote directly to Munchies from the email address on the internet, and then secondly I asked governance to make sure it was forwarded when this was adjourned, and we got absolutely no response back. I think I went to governance a third time just to check that it had gone through, and I copied them on. So one was a direct approach by myself, and the second one was through Munchies, and they also through governance.
We may need to check the email address that was used for that, because that is not something that has landed.
Governance forwarded it to, in case I got the wrong address, Munchies, governance was forwarding it directly to Munchies to provide our address for contact.
That's not something that's accepted on this side of the table, so we're going to need to do some investigation to see what happened there, because meetings offered were not received by the directors of this company.
And was there any approach from your side to us? Because it's quite clear we're a small muse, there's 8. None of you have reached out to us either. Nobody rang any doorbells, nobody put any flyers through. I'm just asking, it's a two-way street.
A lawful consultation, there is a prescribed consultation process that must be followed. I don't want to get into a tit-to-tat, Chair. I want to go through you, if I may, please. The point was in relation to your colleague's comment about it's fantasy to think that it's possible to complain, and I just wanted to seek some clarification as to what the residents understand by the licensing review process, which has a lawful timetable set to it. If the council receive one, they're required to process it within the legal time frame. I just wondered if the residents were aware.
So I think reviews are incredibly hard to obtain. The evidence you need, the level, from my experience as a ward councillor, I would always recommend that a licensing committee put on as many. Basically, you've got people here in a room. You try and do the best you can for the residents. Whilst maintaining the balance, because frankly it's better time spent for everybody if you put your conditions and your controls on at this stage than if you kick it down the line to being a review. So I recognise there is a review process. It is incredibly onerous and it is incredibly anti the individual residents in terms of pushing to a review process.
Well, Chair, that's not accepted, but perhaps that's something we can deal with in a later stage. And also, it's not really a question, but it's something I will need to raise. I haven't understood what the proposal was in relation to controlling pick-up points through the app, because that isn't something that Munchies or a company like it would be able to control. Are we talking about the delivery app, like Uber Eats and Deliveroo? Because that isn't something that Munchies could control their end. Perhaps that's just something we can explore when we come to it.
So at this stage, I'd like to ask our legal officer to deal with the draft conditions and any other queries that he may have.
So does everyone have a copy of the draft conditions document? Obviously, the fact that we're discussing conditions doesn't mean that the committee has made up its mind either way, whether to grant or reject the application. It's just a discussion of conditions that might be imposed if the application were granted. Just turning to the applicant first, you'll see at the end of the document there are 3 further conditions which have been suggested. So if we go through them one by one, condition 10, which essentially requires the provision of a delivery service policy. Any comments, objections?
I would like to have the inclusion that they liaise with the providers of the services to see whether they could provide additional information about parking.
Could I also ask, on that sort of policy, do residents have any say in what gets put into the policy? Because it appears as if it's the premises licence holder comes up with the policy and just sends it to the council and that's it. Doesn't appear as if any third party or any other party, not even the council, has any say in the policy. It's merely obtaining a copy of it.
Shall we ask the applicant to comment first on the way it's currently drafted, and then we'll consider the 2 further points that have been raised. So as it's currently drafted in the document.
Yeah, the answer is yes. Something along these lines can be done, the provision of a strategy with the reality that there are certain things that the delivery companies themselves have exclusive control over, such as the app point that we made earlier. But in terms of drafting and writing a policy to be submitted to the council with things like the availability of a toilet, for example, or providing feedback to the drivers if any antisocial behaviour comes to attention. There was a condition already suggested by the Environmental Health Officer, and I don't know where that's gone, but the original Environmental Health Officer condition was that delivery drivers should wait indoors. That could go into the policy. So yes, provision of a policy could be done.
Thank you. And then the 2 further points that have been raised. First from Councillor Wade. Would it be possible to add in something to the condition, into the condition saying that it will also address where delivery drivers are going to park?
No, because that isn't something over which the licensee has any control. Firstly, that's a planning issue. When the planning permission was originally granted, and it's a highways issue to the extent that delivery drivers have to comply with the law of the road like everybody else. So to have a condition, for example, not to park on double yellow lines or not to park on zigzags, I don't know how a licensee would be held accountable or enforceable if that condition were broken and then that was a Section 136 offence. So I'd have some concerns about that. I think issues could be put into the policy to provide feedback or advice, but in terms of taking control over where drivers park, ultimately that isn't in the gift of the licensee.
I think it was just a recommendation. It's clearly a problem, and I'm sure that you have a very good relationship with, as you mentioned before, you already work with some of the organisations. I'm just asking you to explore that, because that is a problem for the residents.
I'm sure the point could go into the policy that the licensee would liaise with the delivery companies if their drivers were causing a problem or repeatedly parking in the wrong place. You've got the feedback line, obviously, for the residents to make complaint, you talked about having a meeting with them on a regular basis, but there is also a dedicated hotline. That's something that the environmental health officer wanted. So if residents were providing feedback or evidence that drivers were habitually parking in such and such a place, I don't see any reason why the licensee couldn't pass that back to the delivery company, Uber Eats or Deliveroo, as a complaint, to say, please stop your drivers from doing this, otherwise we will have an issue with you. All of that kind of thing can be done on an advisory basis, but I wouldn't want a condition that said the buck stops with the licensee if somebody breaks the law of the road, because that clearly isn't how the law works.
Okay, thank you. And then finally on condition 10, Councillor Gardner just now, on behalf of the objectors, suggested that potentially there could be something requiring consultation with local residents before the policy is submitted to the licensing authority. Agree, disagree?
To get feedback, I mean, you could circulate it, and if there's any feedback, you could take it into consideration. There's no, I don't think there's any problem with circulating a proposed policy to get feedback. What we can't have is a veto. That's got to go to the responsible authorities for them. But certainly to take feedback from residents if they have any particular concerns or issues that they'd like to be fed into it, can't see a problem with that.
Okay, thank you.
Sorry, that sounds very good, but it doesn't address the point that I was trying to make earlier about on the face of the condition, even as adjusted as you suggested, there's the ultimate arbiter as to what the policy contains and whether it's sufficient on the drafting, as opposed to, I think, I'm not sure whether it's the applicant's intention, but it lies with the applicant, not with the licensing authority, and it ought to be at least to be served on the licensing authority and to be acceptable or reasonably acceptable to the licensing authority.
So you're suggesting that the policy would have to be approved in writing by the licensing authority, for example?
Ideally, yes.
I'm going to have to dig heels in a little bit, because if you go down that route and then you get into a Mexican standoff on a point of drafting where the policy has been submitted but an officer in the council won't accept it for this reason or another, you place a licensee in the position where they're committing a criminal offence. And you can't do that. That's not acceptable. These sorts of conditions are intended to make sure that a licensee is upholding the licensing objectives in the best way that they can. In terms of enforcement, there are some difficulties with enforcing conditions like this. They are goodwill conditions to a large extent, and you'd rather hope that licensees would do it anyway. But in terms of imposing them on a license, they come very close to the wire on the legality for conditions, which is set out in the Section 182 Secretary of State's guidance as to what a condition ought to be. So to go that far, I can't accept that, because otherwise you get into this standoff, as I say. If in actual fact what you're finding is that delivery drivers are causing actual problems, then you might, as I keep coming back to, look at reviewing the licence. And I don't accept that the review of a premises licence is a difficult, dangerous or onerous activity at all. Residents can put in an objection that they have, and as long as it's not vexatious or frivolous or repetitious, as the law says, then the committee has no choice but to hear it. They have a 28-day consultation period and 20 working days to list it in front of the committee. There's nothing delayed or difficult about it at all.
Okay, thank you. I think that's everything. We understand the position on condition 10, what the objectors are asking for, and the applicant's position. Condition 11, CCTV condition, any concerns, objections?
No, not at all. The premises does that already. I think a condition was already agreed with the EHO. If that's the preferred wording, that's fine.
Yeah, I don't think it had been agreed, but that's just sort of the standard RBKC wording. Yeah. And then condition 12, incident log, any issues, concerns?
Well, it's a bit cut and paste because it talks about refusals of sale of alcohol. So I do think it ought to be amended so it's pertinent to the premises to which it is to be applied. But in principle, no. So you'd be striking through H. But other than that, no.
Okay, thank you. That's a fair point on alcohol.
We've got some other potential conditions that arise out of the discussion today at a time that suits you.
Sorry.
Yes, that's what I was going to move on to now.
Can I just go back to 12, please?
Yes.
It's notable, given the discussion we've been having about couriers, it would be helpful if that 12 could actually also include a log of any courier complaints or any takeaway complaints. So we talk about noise nuisance, we don't talk about littering, and we don't talk about couriers. So if that could be included, it would be helpful, thank you. If there were any reported instances or complaints about them, please.
So something like any complaints made about delivery drivers.
And littering.
Well, let's just be clear about this. If the premises have an issue with a delivery driver, they can record it contemporaneously. If a resident makes a complaint to the premises about something they have perceived about a delivery driver, where would that be? When would that be? You might have a resident complaining to Munchies that they saw a delivery driver doing something half a mile down the road 6 months later. If you want that recorded in an incident log, so be it, but I'm not quite sure of the value of it. So that part I'd have an issue with, and I would have thought it would be more advantageous for the residents to use the hotline and report it contemporaneously to the premises. I don't see the value of adding it to an incident log.
Well, recording what came through on the hotline at least would be useful. Recording what complaints come through on the hotline at least would be useful.
If there's a complaint that comes through on the hotline, if you want that recording in the incident log, I can't see a problem with that.
And littering, please.
Yes. So thank you. That's the conditions in red. During the course of the hearing today, there's been a few other potential conditions mentioned. The first, I believe, was raised by Councillor Wade in relation to having kind of meetings with the local residents association twice a year in order to discuss any issues arising from the operation of the premises. So the condition would essentially require a meeting with the local residents association twice a year. Any issues, concerns?
Not in principle, but we need to just tidy up the methodology because sometimes that causes problems. So it would need to be a meeting that's within the control of the premises to call and do. You couldn't leave it to the residents to call a meeting twice a year, but they don't do so. And then the premises are in breach of their condition because it hasn't happened. So it has to be a meeting that's called by the premises.
And advertised so that
Yep.
informing the residents' associations.
Yeah, absolutely.
And also clearly advertising in the window, not a small thing, and advertising so other people might be aware that aren't members of the association.
Could I suggest, I'm going to read this quite slowly, but a condition that's been used before is the premises license holder shall organise and accommodate meetings to discuss the operation of the premises with residents at least 2 times per calendar year, which are a minimum of 5 months apart. The detail of the proposed meeting shall be clearly displayed on a window or door visible to people outside the premises, and the premises license holder shall directly notify ward councillors and residents' associations of the meeting date at least 2 weeks before the meeting. The premises license holder shall take the minutes of meetings with residents that shall be circulated to attendees and to the licensing authority, and copies shall be readily available at the premises upon request.
Could I just add that it would be very useful to leaflet those flats above Pembridge Road There are not many of them for the very reason that there is no official residents association for them. We have our own, but it's just there's what, 20 flats and houses just along that street.
Well, the meeting would be advertised on the premises, so
I
anyone
think your
walking.
phraseology was residents associations and councillors, so that's why my comment is that it should be residents. I was trying not to throw it too wide.
Joanna, that's the reason why it goes to the councillors of the ward as well, because you'll have your own lists, and then it's possible for a wider circulation than just a members because of your residents association.
So from the applicant, any issues with the condition or something like it that I just...
No, that's fine. The wording is fine. I want to make sure that we avoid anything within the wording that presupposes that the meetings will be attended. The onus is on the licensee to convene a meeting, advertise it, circulate it, but if nobody turns up, that's not their fault and they're not in breach of their condition.
Sorry, did the condition contain how much notice you have to give? It's 2 weeks.
2 weeks, yeah.
In which case, no.
Yeah. Yes, that's fine. Let me just, check my notes. Condition 5 on the proposed conditions is the litter pick. I suppose at the moment it says litter is regularly collected from the area outside the front of the premises. Would there be any scope to expand that to include Bolmer Mews? Yes or no?
The answer is no. You can only impose conditions on the licensable hours. What I'm told is that the premises will collect litter and they will go further and they will go down to Bulmer Mews and they will collect all the litter, not just their own. But I can't have that as a condition on the licence because that would mandate it during nighttime hours. So I'm afraid that this is going to have to be one that is done on goodwill and understanding. And if the licensees don't do it, and it's noted that they don't do it when they said that they would in a licensing hearing, and other things come to light as well, no doubt that will also be held against them. But as far as a condition is concerned, I am very anxious about having conditions that mandate people, perhaps young staff, perhaps females, going beyond the premises demise in the hours of darkness. That's not a good idea.
Okay, thank you. So it could be recorded in the decision, it could even potentially be an informative but not a condition, is your position. Okay.
An expectation, if you like, words of advice, if you like, anything along those lines, that's fine.
In other conditions that we've submitted for similar problems, it's actually defined the radius by meterage, and in some cases it's 50 meters and sometimes it's 100. So I think just saying outside the premises doesn't acknowledge perhaps some of the problems.
Not everybody knows the things that I know, unfortunately, when they submit conditions, and they may not have taken into account the crossover with health and safety and the crossover with insurance problems. And if you send young staff out a certain distance beyond your premises, you will fall foul of both of those things. I don't know whether other applicants to you have taken that into account or not, but I am.
Okay, thank you. Then I think just finally, just to ensure we haven't missed anything, I think if we go to page 40 of the agenda pack.
I'm sorry, Chair. There were a few points I raised earlier about conditions. Have they been noted?
Yes, I think we're turning to them now, but let me know if we miss anything.
Thank you.
Because it's page 40 of the agenda pack, where in the Bulmer Mews Residents Association representation, there were a number of conditions suggested. Perhaps it might just be easiest if the applicant were to comment on each of the conditions that are listed there. I think some of them are already proposed or included on the license. So number 1, the front door being kept shut except for access and egress after 11 p.m. Do you think that's...
And sorry, that should also include the window that was made by my neighbour. I think the front window also opens.
So door and window being kept shut. Do you think that's necessary, proportionate?
No, that's a condition for alcohol licensed premises for the control of the emission of noise from inside the premises. I don't think anybody's suggesting that they've got a problem with the emission of noise from inside the premises. There's another one at 5 about music. So there's clearly a misunderstanding as to what's going on here. The door will open and close whenever anybody goes in or out. We've got to think in terms of how a licensing officer or an environmental health officer would enforce this condition and what it would actually mean on the front line if they turned up to say, well, hang on a minute, your front door didn't close immediately after that person went through it or something, or somebody else held their arm out to hold it because they were going to go. It doesn't work. It's not necessary. It's not proportionate.
Okay. Thank you. Conditions 2, 3, and 4. Ms. Clover, correct me if I'm wrong, but I assume that that would go against the purpose while you're applying for the license, so you wouldn't accept those. Condition 5, no music or amplified sound. Well, I'll let you comment. There's no music hasn't been applied for.
There's no music at all, not even background noise. Not even background music, rather.
Okay. Smells generated, I think, is a condition that's been agreed.
It's a planning issue, I would say, but it's been agreed with the environmental health officers, so I say no more about it.
And same with noise or vibration.
Yep. Which takes care of any music issues. As it happens, you wouldn't need both, but as I say, there's no music.
Then rubbish has also been agreed.
It has, but I've got a problem with that, apparently, because although the environmental health officers put forward those hours, I'm told the rubbish is actually collected by Kensington themselves. And so we are bound by the hours that Kensington collect the rubbish, which is, there's one collection at 2 a.m. and there's one at 6 a.m. So what we can't have is a condition that conflicts with the rubbish times that Kensington actually want to come and collect. If it was an external rubbish collector, that would be one thing, but it's not. So I'm afraid that's going to have to be reconciled.
As I understand it, you can pick different litter collections for RBKC, including one at midnight. You don't have to go for the 2 a.m. and you certainly don't do the 6 a.m.
There's a standard one. There's standard one at 2 o'clock in the morning.
Except there can be an advantage of having the food waste taken away that night, so that you don't have foxes coming to get it.
I'm told we're not given a choice. It's collected when it's collected.
Okay, so that condition will...
check that, please, with the
Sorry?
waste. Could you go and check with the waste? That would be very helpful.
Well, okay. So the applicant says that condition will either have to be removed or will have to provide an exemption where the service is provided by the council themselves. Refuse. So, sorry, just to be clear, that would be for refuse collection rather than depositing rubbish outside the premises.
Yes.
Yes.
Yeah, so what these premises do with their rubbish, in actual fact, they don't have the noisy bottling out that a pub would have, but in terms of when they put their rubbish out, you can comply with that.
Yes.
So we can comply with when we put our rubbish out, but we can't comply with refuse collection.
Thank you. Deliveries, I think, is agreed. Litter, we've talked about. Legible notices is agreed. Phone number is agreed. Dispersal policy.
Again, that's alcohol premises typically. I mean, you can. I don't think the licensee objects to a dispersal policy, but what that really comprises is members of the staff moving people on if they're causing a noise or a nuisance of some description outside the premises. If you want that written down as a policy, then I'm sure that could happen. But again, there has to be a certain amount of common sense built into this.
Okay, thank you. I think has that covered? No, what, sorry. Well, let me know what else.
It was just, I think, I got some nods from across the way on adjusting condition 1. So it's any person waiting to collect must do so inside the premises. And also, I think there was the committee themselves raised the access to the loo for couriers. Again, any person would be useful.
Yeah, there's no problem with couriers or any other person waiting to collect food doing so inside. The vast majority of people would do that anyway. In terms of toilet, the toilet will be made available. It's a customer toilet, so that there's no issue with making it available for customers. I'm always a little bit nervous about over-conditioning. It starts to get to the stage where it becomes a bit nanny, that customers will be allowed to use or must be allowed to use the customer toilet. I don't think that's a suitable condition, but in principle, the toilet is there, it is available for customers and delivery drivers.
It could perhaps be something to be covered in condition 10, the policy on delivery. So we could say that it should be included in the policy in condition 10, access to loos for delivery drivers.
Just one other thing about staff and others gathering for smoking and vaping outside the premises. Maybe that's another policy point rather than the condition point about staff not smoking outside the premises in front, particularly during the licensing hours.
Well, again, they wouldn't be allowed to do that, and it would be contrary to their contract employment. So I'm a little bit always unhappy about putting 35 conditions on a license which stray out of the territory of something that the management would do anyway and is not actually impacting on the residents. I'm not aware that residents have said that they are disturbed by staff at Munchies vaping outside the front door.
Perhaps even if the committee could record that was specifically represented that management controls smoking but the staff, that would be helpful to us.
Get that? I didn't hear that.
I think he was asking for any decision to record that the management controls smoking and vaping by staff outside the premises.
These are conditions on a late night refreshment license. When you start to get into the control by management of their staff, that's starting to move outside of the licensing remit, I would suggest.
Okay, thank you. I think that's everything on conditions. So thank you, that's been helpful. Yep.
Okay, so our licensing officer, Mr. Phelan, have you anything to add?
Nothing to add, thank you, Chair.
And our governance officers, anything to add?
Thank you, Chair. Nothing to add from us.
Thank you. We have reached the end of the meeting. The committee now has all the information needed and we will retire to make our decision in private session. We will not announce the decision today. Instead, the hearing will be closed. A summary determination will be sent to the parties within 5 working days of today's hearing, and a full decision will follow as soon as possible thereafter. The time limit for appealing the decision will not commence until the full decision has been sent to the parties. Thank you all for attending. The hearing is now closed.